Madam Clerk, would you open the courtroom for us, please?
The State of Michigan 36th District Court is now in session with the Honorable David S. Robinson Jr. presiding. Good morning, Your Honor. Good morning, everyone.
Good morning. I think this is probably work here. Mr. Burke?
Hello, Your Honor. How are you doing?
I'm well. How are you today? 664. It's this one
Good,
here.
thank you.
Hello? We are on the record. This is 22-198-664. Doctors Harris Burkill Songi versus Sharona Fikes. Date and time for pretrial. Your appearance.
Thank you, Your Honor. Hal Burke, P69068, attorneys for the plaintiffs in this case.
And your name, ma'am?
Sharona Fikes.
What's our date for our case evaluation? Is that set?
No.
Mr. Burke?
Your Honor, after the last court hearing, I called, and as Ms. Fikes stated, I left a message. I'm at the mercy of them. I've left actually 2 messages, and I have a contact there through email who has not replied to me. As Ms. Fikes stated, it has not been set, not out of lack of effort by her or candidly by me, but we want it resolved, of course.
I'm sorry, I haven't received any phone calls or emails from you.
No,
Well,
I didn't
you
call
were
you.
not
I
called.
didn't call you, Ms. Fikes.
Oh, okay.
I called the mediation evaluation department.
Okay.
I'm gonna set this over for 1 week. I want this set.
I'm sorry. I won't be in Detroit in 1 week, Your Honor.
I'm sorry, ma'am. What'd you say?
Your Honor, I won't be in Detroit, Michigan in a week. I won't be returning to August 1st. I'm leaving on the 22nd to see my daughter who moved to Nashville, Tennessee, for her job. She's young.
Today is what day? It's ridiculous.
It really is, because I have insurance. I've always had medical insurance.
Well, I'm talking about being able to get this case set.
Yes, sir.
You coming back when, ma'am?
August 1st.
All right.
And
Right.
then this case, this same doctor is suing me twice. So I have a pretrial August 2nd with another judge, and then we go to trial on August 22nd in person.
All right, then I'm gonna set this matter for August 14th. If this matter has not been set for case evaluation by that time, I'm gonna have to deal something with this different. Mr. Burke, I want to see some efforts on your part, sending that order over again to case evaluation. Tell them I want it set.
I agree, Your Honor. Thank you.
August 14th, 10 o'clock will be our next date. And hopefully by that time, we'll be set for our case evaluation. Thank you for coming in.
Thank you, sir.
Thank you.
Ridiculous. August 14th, 10 o'clock. Mr. Cobb,
Morning, Judge. Good morning, Judge.
your client, Mr. Wallace, is here. So I'm going to mute him so he can see what's going on.
Sure.
Get Mr. Crowell in here and get started here. All right, we are on the record. This is 22-196-478. Gregory Wallace, Brandon Robinson versus Progressive Insurance. Your appearances.
Good morning, Judge Michael Cobb, P78658, here on behalf of Mr. Gregory Wallace. Mr. Wallace, could you state your name for the record?
I have muted Mr. Wallace.
Okay. Well,
Both he and Mr. Robinson are present, but because the counsel is here, I have muted them.
Okay, we do agree to having this hearing via Zoom.
Yes,
Counsel,
good morning, Your Honor. Adam Kroll on behalf of defendant Progressive.
you remember the State Bar of Michigan?
Yes, member of State Bar of Michigan, P number 83857.
All right, well, we have a couple of issues here. First issue is that there's supposed to be, the defendant is still in default in this matter. Plaintiff was to file a first amended complaint within 14 days. That was not done. The defendant was to file an order setting aside the default within 14 days of our last pretrial on June 20th. That was not done. Somebody want to explain to me why?
Your Honor, I filed my amended complaint on June 30th. I believe that was within 14 days of our last hearing, Your Honor. I looked at the Register of Actions this morning and it did reflect that I filed that, and I've sent that to the other side.
All right, that'll catch up with us later. Mr. Cobb, how many plaintiffs do you have now?
Your Honor, I believe at the last hearing, I was instructed to remove Brandon Robinson
Because
from.
he was not the proper plaintiff. He was trying to act as a lawyer on behalf of his dad.
Well, Your Honor, I believe that's also part of what I received from defendant this morning. I received an answer from defendant. I believe that his position as power of attorney over his father does kind of muddy the waters as far as defendant may understand, but I don't think it was his intent to act as his father's attorney. I believe because his father has cognitive issues because of age and dementia, he was just acting on his father's behalf through his power of attorney, not as an attorney for the state of Michigan, Your Honor. So I think that may have been the misunderstanding.
Mr. Kroll.
Yes, Your Honor, I have in my file the order signed or order granting defendant's motion to set aside default that was signed and dated June 27, 2023 by the court. I believe based on my timestamp, it may have been received.
It's not
June
law
20th.
for whatever reason. Okay. All right, so where are we on this file, gentlemen?
Your defendant has filed an answer and requested a jury demand. It's my understanding that we've actually gone through the discovery process prior to, today's hearing. I think defendant is seeking additional discovery, but upon information and belief, there's already been considerable discovery that's taken place.
Mr. Kroll?
Judge, we do need more time for discovery, as all the discovery was handled by Mr. Robinson, who is not a party or an attorney in this matter, and therefore we need to essentially redo all the discovery and get it actually legitimate discovery and responses and exchange requests that we have. And we're also not sure if they're claiming if their claim is above the jurisdiction here, as we believe the damages are more than the 25,000. So we do request additional discovery of at least 60 days.
Well, let's find out first of all, Mr. Cobb, what is your amount of money that you're claiming here?
We're not seeking anything in addition beyond $25,000. We're not. We're
Okay.
seeking.
Well, that resolves that problem, Mr. Kroll. There's no No issue in regard to that. So, Mr. Kroll, did you send an answer to the First Amendment complaint to the court? Apparently you guys have something I don't have.
Yes, Your Honor, the answer was sent or to the court this morning. It was just answered. I don't know if the court received it yet, but it's
Well,
either.
no, obviously if you sent this morning.
Yes, Your Honor, I wasn't aware. Sorry, I remember now that the 36th, your court, it does not have the e-filing for us. I apologize, but no, it's on its way, but it has been emailed or, but
Put
it
it in
has.
mail. Okay,
worked.
here's what we're going to do. I'm going to see you guys again on August the 14th at 10 o'clock. I'm going to continue your written discovery until that time.
Thank you, Your Honor.
Is there anything else we can accomplish today?
Not at this time, Your Honor. Unless the court would like to schedule a trial date in this matter.
Well, that's not, I don't schedule trial dates until we figure out what's going on with the file. And what's happening now is that because through no fault of his own, your client was trying to do things he wasn't entitled to do. There's some procedural hiccups that need to be ironed out. So let's get that done, and then we'll look again, see where we are. Now, the other thing is, if you are, Mr. Kroll seems to think that there's some possibility that you're in the wrong court, because he thinks that your damages may exceed the court's jurisdictional maximum. So that's something you want to look at before we're together again. I will see you guys again, August 14th at 10 o'clock.
Thank you, Your Honor.
Your written discovery will remain open. Okay?
Yes, thank you, Your Honor.
Anything else?
Just want to address, there is a issue with rescission of this underlying policy. I want to note for the court that there is potential for us to file a motion for summary disposition. I just don't want to miss any deadlines in that regard.
Well, what I'm going to do is I typically allow the parties to run discovery until they tell me they've exhausted what they need, until somebody isn't doing any work, at which time I will close it. And then at that point, when I close discovery, I will ask the parties whether there's any dispositive motions to be filed. If there are, I will set a deadline for those motions to be filed.
All right, thank you, Your Honor.
Your Honor, may I say something?
Sir, you have a lawyer here. You should talk to your lawyer.
I think we're okay for today. Just give me a call and
You
we'll
want me to
speak.
put you guys into a chat room?
Sure.
Okay, I can do that. All right, so we're done. August 14th at 10 o'clock, your written discovery remains open. I'm going to put Mr. Cobb and his clients into a chat room.
Thank you, Your Honor.
Let's be safe, gentlemen.
You too.
All right, so that's going to be Mr. Wallace and Mr. Cobb. Hit join, Mr. Wallace. There you go. That's gonna conclude the morning